4 decades. Her expertise spans a wide spectrum of legal matters, from constitutional law and corporate litigation, including infrastructural projects, to environmental law, property disputes, and Waqf matters. She will now take the stage to deliver the welcome address and introduce our distinguished guest, Justice Nariman.
Honorable Judges of the Supreme Court, Honorable Judges of the High Court, Attorney General for India, distinguished guests, dignitaries, friends, and members of the legal fraternity. I stand here on behalf of my family to welcome you all to the inauguration of the Ahmadi Foundation, which honors the legacy of my father, Justice Aziz Mushabbar Ahmadi, and my mother, Mrs. Amina Ahmadi. The foundation has been formulated to emulate and continue with the ideals of my parents. My father was known to be a man of action. Justice for him was not only a concept to be written or spoken about. For my father, true justice went beyond the legal framework into the heart of society. It was a responsibility to empower the voiceless, uplift the downtrodden, and create a space where every individual had to be treated fairly with respect. He ensured that his belief in justice, compassion, and the transformative power of education was translated into action, bearing tangible results. Harmony in our social fabric was one of the cornerstones of Justice Ahmadi's beliefs. He believed that harmony was fostered by respect and fair treatment of all, be it by the state, the court, or a person or group that was in a dominant position. For that reason, he was also a strong believer in mediation. A prompt solution-oriented justice delivery mechanism was his relentless endeavor. With the advent of digitization and social media, the legal and social landscape is experiencing a transformation. In this entire transition, the ideals propounded by Justice Ahmadi remain as relevant now as they were then. Be it in his faith in constitutional values, his efforts towards judicial reforms, computerization of all filings and listings in the Supreme Court, expeditious disposal of cases, his code of ethics, his sense of duty, or his faith in humankind. He was a firm believer that right would always undo the wrong, and that fear had no place in a principled world. The principles that my father stood for were shared in equal measure by my mother. My father's achievements in his public life came with the stupendous support and sacrifices made by my gentle mother. She always stood by him, his gentle, quiet pillar of unwavering support. The spirit of the Ahmadi Foundation is not just a tribute to Justice Ahmadi's work. It is a hope, a continuation of his mission rooted in the values of humanity, compassion, and equality. It is about listening to voices that have been silenced, fighting for the dignity of the most vulnerable, providing opportunities to the downtrodden, obliterating divisions on lines of caste and religion, and protecting our hard-earned freedom of speech, expression, life, and liberty. The Ahmadi Foundation aims at organizing seminars, workshops, and public lectures on legal and social issues, encouraging civic engagement and facilitating constructive dialogue among stakeholders. It is inspired by the principles that epitomize the life of Justice Ahmadi, both in the legal and humanitarian field. Justice Ahmadi always believed that academic institutions and non-governmental organizations were capable of bringing a positive change in society. The Foundation will strive to work in socio-legal and humanitarian fields by bringing together legal experts, academic institutions, and scholars, and providing them a platform for an outcome-oriented discourse to tackle various socio-legal issues throughout the country. The Foundation will further aim to exclusively unite with legal academic institutions to bridge the gap between industry and academics, and further the objective of holistic legal education in law schools, which is one of the many objectives that Justice Ahmadi truly believed in. We hope that over time, the Ahmadi Foundation plays an important role in the betterment of our country for future generations. I have the pleasure of announcing that in honor of and to preserve and promote the legacy of late Justice A.M. Ahmadi, the National Law School of India, University, Bangalore, has instituted the Justice Ahmadi Initiative on Rule of Law, Democracy, and Social Justice. The initiative will work The initiative will work to advance the ideas Justice Ahmadi championed throughout his distinguished career, including but not restricted to human rights, education, inclusion, and protection of vulnerable communities, judicial independence, alternate dispute resolution mechanisms, and strengthening of democratic institutions. To begin with, the initiative will focus on organizing an annual distinguished lecture. The Ahmadi Foundation and NLSIU Bangalore will work together to eventually establish an endowed chair in the name of Chief Justice A.M. Ahmadi, at which point the chair will subsume the initiative. And now, a special welcome to our honor speaker, Justice Rohinton Nariman. We are lucky to have him to deliver. We are lucky to have him deliver the inaugural lecture of the foundation, not only because he's one of the best, but also because he was very dear to Justice Ahmadi. Justice Nariman was kind enough to spare his valuable time to deliver this lecture, and we are very grateful to him. Justice Nariman's legal practice started in 1979. His brilliance was such that the rules had to be changed to ensure that he could be designated a senior advocate of the Supreme Court at the young age of 37. He held the position of Solicitor General for India before being elevated as a judge of the Supreme Court. He retired in 2021, and we miss him on the bench. Without taking up more time, I will request Justice Rohinton Nariman to come on the stage to deliver the inaugural lecture of the Ahmadi Foundation.
Honorable judges of the Supreme Court, past and present, honorable judges of the High Court, Mr. Attorney General, members of the Ahmadi family to whom I am extremely close, ladies and gentlemen, this is not the first lecture and the first release of a book relating to Justice Ahmadi that I have delivered. I must tell you that in 2016, there was a book entitled The Chief Justice Speaks. It was a great misnomer because this was a Chief Justice who did not speak, he listened. But anyway, the book essentially consisted of articles and speeches of Justice Ahmadi when he was alive. And that smiling face evokes such pleasant memories. Unfortunately, I today have to deliver this lecture after his demise, but he lives on in our hearts and our minds. Secularism was a subject particularly close to Justice Ahmadi's heart. As a matter of fact, our Indian tradition of secularism goes back at least 2,200 years. Because our two greatest emperors, Emperor Ashoka was around 2000, in fact 250 BC, and Emperor Akbar was much, much later, embodied secularism in every way. And they actually embodied the positive aspect of secularism, which is equal respect to be given to every single religion. And this is a very diverse country with very diverse people and very diverse religions. Now, so far as constitutional democracies are concerned and written constitutions are concerned, of course, it is the US Constitution that one goes back to first. And surprisingly, in its cryptic 6 articles, it only had Article 6, which spoke of no religious test having to be taken if you were to hold an office under the United States of America. The First Amendment, of course, came 2 years later, and equally cryptically, in about 16 words, said Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, on these words, built a huge jurisprudence by the US Supreme Court. And they invariably referred to a letter written by President Jefferson in 1802, which spoke of the wall which separated church and state. Now, this wall, through the last 225 years, began in the United States by being the Great Wall of China, impenetrable, large, and a wall which genuinely separated church and state. Slowly, that wall was whittled down to being Hadrian's Wall, which then became a wall much, much lower and much less in extent, and has finally landed up in 2022 by being the wall referred to in Midsummer Night's Dream as Act 5, being the wall which separated Pyramus and Thisbe, the two lovers who could whisper sweet nothings to each other through cracks and crevices in the wall. You begin with an early judgment of Reynolds versus the United States, where a federal anti-bigamy statute was challenged by the Mormons. Now, the Mormons, you'll remember, are a Christian group who believe strongly that they should marry, that the band should marry many wives. And they said, this is part of our basic belief. And in a judgment by Chief Justice Waite, he said that may be a part of your belief, but that doesn't mean you have the license to do something that's criminal, because the statute proscribed this as being criminal activity. And the first test, therefore, laid down was that so long as you are within the bounds of liberty and not license, and you are within the bounds of the law, you can practice your religion freely. But if criminal law intervenes, then so be it. That necessarily interdicts your right. Now, after that, a series of judgments followed. And the 14th Amendment was then applied to the states, so that state laws also had to conform to the First Amendment. And in the Everson judgment, which was a 5-4 judgment, the wall was strong and very, very tall, because it very clearly said that the state has to have its hands completely off religion in every possible manner. This then gave way to what was called the Lemon test. Lemon versus Kurtzman was a 1971 judgment in which Chief Justice Berger laid down 3 tests. He said, if you are impugning a statute on the ground of the First Amendment, first thing that you have to ask is, was the objective of the statute secular? Second, if it was secular, then what effect did it have on religion? If the effect was neutral, again it passed muster. But then third test was a little intriguing, because it said that having passed these 2 tests, if there is any intertwining with religion which is beyond a certain point, which was unstated, then of course the statute would have to be struck down. Now, this left the law a little uncertain. And finally, now in a judgment in 2022, which was Kennedy versus the Bremerton District, Kavanaugh J. ultimately held that a football coach who knelt down in prayer before a football game and was joined with some of the students who were all part of a state club did not breach the First Amendment in so doing. And he held, therefore, that the Lemon test has now gone, and it will be replaced now with no hands-off test, but with a hands-on test, the only thing being that one must see that the line where religion and the state mix doesn't go beyond a certain point. This is the uncertain state of the law in the US. When it comes to us, even though we had a Government of India Act of 1935 by the British Parliament, And even though the British Parliament in 1900 had enacted a section 116 of the Commonwealth of Australia Act, actually incorporating Article 6 and the First Amendment, our government of India Act said nothing whatsoever about religious freedom. So our constitution therefore started on a completely clean slate. As you know, the word secular was only added by the 42nd Amendment. It was not there in the original constitution. But what was in the original constitution was the word secular in Article 25(2)(a) as meaning something not connected with religion. That's about as far as we go. And in the debates, K.T. Shah tried to add the word secular, but was turned down saying there's no necessity, because the Fundamental Rights chapter contains various positions on the word secular. And as a matter of fact, the 45th Amendment Bill that was sought to be passed by the Janata Party in 1978 tried to define a secular republic as being a republic in which there was equal respect for all religions. But even that didn't pass muster, largely for the reason that they didn't control the Rajya Sabha at that point of time. So when we come to our constitution, where do we find secularism and what exactly does it mean? You have, in the Fundamental Rights chapter itself, various rights which are spoken of, which ultimately delineate four different aspects of secularism, as we know it. The first aspect is that the state shall not discriminate, and on grounds only of religion. The word used is only. This came up in State of Bombay versus Bombay Education Society, 1955 judgment, in the context of a language. And it was said that whatever the object of the act, and this was following what the Privy Council said, whatever may be the object of the act, if the effect was to discriminate on the ground of language in that case, then the statute will be bad. And only doesn't necessarily mean that there should be some other ground supporting it. Now, this unfortunately was not the law laid down in Air India versus Dargesh Mizia many, many years later. But then this judgment was not adverted to, and it's a 5 judgment. So the first thing that we are told is that the state shall not discriminate. The second is that the citizens equally cannot discriminate against each other on grounds only of religion when it comes to certain public spaces and public parks, restaurants, hotels, etc. The third is the single most important aspect, which is the right or the individual right of each person or each citizen in this country to practice, profess, propagate religion. And the fourth is the so-called wall in the United States, which is not impregnable here, but the wall which says that when the state actually runs an educational institution, for example, by itself, it cannot teach religion. Equally, it cannot collect taxes and defray them only for a particular religion. Now, going to number 1, we have Article 15(1), which, as I told you, states generally that the state shall not discriminate in all spheres of activity on grounds only of religion. We are not concerned with the others here. This is the widest. And 16(2) then is a species which says that so far as you take an office under the state, equally the state can't discriminate on grounds only of religion when you apply for that office under the state. When you come to individuals having to discriminate against other individuals, you are covered by a separate article which is 15(2), which is very, very important. And this has to be read along with 29(2). And what do they say? They say that the moment there is a restaurant, a hotel, a place where the public go to for entertainment, etc., even a private owner cannot discriminate on grounds of religion only. And when it comes to tanks, bathing ghats, wells, etc., either maintained by the state wholly or otherwise, or which are dedicated to the public generally, there also citizens cannot discriminate on grounds only of religion. This spans over then under 29 to admission to private educational institutions. Because the moment the state gives aid to private educational institutions, which they cannot survive without, the private educational institution, once it receives aid, equally cannot discriminate on grounds of religion, language, etc. So we have facet 1, which is the state shall not. Facet 2, and of course facet 1 is the widest because panoply is very vast. Facet 2 is limited to areas of public entertainment, etc., bathing ghats, wells, etc., and admission to private medical institutions. Facet 3 perhaps is the single most important, and that is governed by Articles 25 and 26. Now, 25 is one of our most elaborate articles in the Constitution, in complete contrast to what is given by the First Amendment. Because in great detail, our founding fathers did a brilliant balancing act between a person who wishes to practice religion and the limits to which he can go. Because after all, we are a very diverse people, and there are diverse persons, therefore, each practicing his own religion. So the first thing 25 tells you is that all persons, this is important, are equally entitled. Now, what does the word equal mean? Equal means whether you are a woman or a man first, you are put on a pedestal of equality. The second is, in any case, you will have an equal go at your religion along with everybody else. So what is important is all persons are equally entitled. Now, to do what? There are 3 very, very important words used: to profess, practice, and propagate. Propagate was not there in the original draft. It came a little later. But profess and practice were. And profess essentially means that unlike in France, for example, you can actually wear your religious badge on yourself. Now, I am a Zoroastrian, so I can actually wear a sadra and a kasti inside me, which you cannot see at all times, 24 hours. And this is explicitly recognized by our Constitution. And explanation 1 goes to the keeping of kirpan. Now, kirpan is an actual dagger, which Sikhs believe that they should keep as one of the 5 Ks that was laid down by Guru Gobind Singh, their 10th and greatest Guru. So, it goes to the extent, therefore, of professing religion, which is you may hold the religious badge on you, open to everybody. The second is extremely important. You may practice. Now, what is practice? Practice is the ritual form of religion, which is, if you are a Hindu who worships idols, the worship of idols. If you are not, then you are a person who can pray in a church or a mosque, or pray in an agyari as we do. And practice equally is in every facet of the word. So you have 2 very wide rights, and then you come to propagate, which is the problem area. Now, why do I say problem area? Because propagate, if one reads the Constituent Assembly debates, was meant to assuage the Indian Christian community. Because they said that it is a fundamental and central part of our faith to be able to convert others to our way of thinking. So finally, they said, all right, if we use the word propagate, propagate would mean essentially appeal to somebody else's conscience. Now, freedom of conscience is specifically mentioned as a fundamental right of everybody in Article 25. So the appeal to another's conscience to change his faith is something that was hinted at least in the Constituent Assembly debates. When we come to our case law on this, it is very little. And there is a direct judgment of 5 judges in Reverend Stanislaus, which upset an Orissa High Court judgment, which had held that the centrality of this tenet in the Christian religion is very important, and that therefore propagate must include to bring over to your point of view. This was upset by Chief Justice Ray on the specious ground that you are trying really to interfere with somebody's right of conscience. It's quite the reverse, actually. You are appealing to somebody's right of conscience. And as a result, we have taken a back seat on the word propagate. Of course, if religious conversions are on fraudulent grounds, there is undue influence, there is coercion, there is force, there is intimidation, that can easily be interdicted under the first 3 expressions, which is subject to public order, morality, and health. But so far as the word propagate itself is concerned, the word propagate, according to me and according to our great author H.M. Singhvi, would clearly mean the right to spread one's faith by legitimate means. That is, the right to appeal to somebody's conscience and no further. Now, all this is made subject to, as I told you, public order, morality, and health. Each of these expressions is also, in one sense, neutral, because public order doesn't depend on which religion or which religious badge you are holding. Public order is something much more than a law and order problem. 2 neighbors having a scuffle is not public order. But if there is a riot on a large scale, then it affects the public order of the state and everybody else around you. And at that stage, the state can walk in and interdict a particular religious activity if it leads directly to a breach of public order. Morality is a more flexible expression. It would obviously include, let's say, temple prostitution, devdasis, sati, female infanticide, and things of that sort. Now, sati, for example, all these were, by the way, proscribed by the British long before. And there was a British general here who was called Sir Charles Napier. And at one stage, he saw some girl being led forcibly to a particular funeral pyre. And he asked the people, the priests particularly, who were leading that girl, what are you doing to her? So they tried to explain in great detail the fact that they have a custom which is called sati, where the widow goes and burns along with her dead husband so that she accompanies him to heaven or wherever else he goes. So he said, oh, very good. You carry out your custom, but then we have another custom. And our custom is that anybody who takes innocent girls and wishes to murder them will be hanged. So you carry out your custom and we will carry out ours. So morality, therefore, is an expression which takes in things like this. And health, again, is a neutral expression. For example, noise pollution today is the one thing that comes to mind immediately. And nobody has a right to pollute the atmosphere with loud bell ringing or with loud chanting or with loud calling to prayer or whatever. So that is another area where the state can step in rightly and control religious voices. Now, when we come to 25(2), you have another very interesting exception. Laws may be made for social welfare and reform. And here there was a contest between the Dawoodi Bohras on the one hand and the state, because the state passed, the state of Bombay at that point, a Prevention of Excommunication Act. And that Prevention of Excommunication Act was a direct affront to their Sayadna, who is their religious leader. The Sayadna, in fact, is an institution which is 1,000 years old. There was an Imam Tayyib who went into seclusion. He was the 21st. And as a result, there was a forceful and brilliant queen called Queen Awa, in Yemen, who appointed the first dai, that is the first person, who will look after the Imam's pontificate, so to speak, till he comes back. And this has continued over the centuries for 1,000 years. And today I think we have the 54th. So this Dawoodi Bohra case laid down some very interesting propositions. There was only one dissent. And that dissent was the dissent of my good friend Shivkirti Singh's grandfather, B.P. Sinha. Otherwise, Dasgupta J spoke for the majority and Rajgopal Iyengar wrote an extremely illuminating concurring judgment. And all of them had to grapple with social welfare and reform. Because what was argued was that, look, if you excommunicate somebody, it's like a civil death for that person. He's out on the street. His children cannot be given names which the Sayyidna alone would give. He would not get married under the auspices of the Sayyidna. He would not be buried in a burial ground assigned by the Sayyidna. So since it's this kind of a death, and it's almost an ostracism from the community also, there are very serious civic consequences, and that therefore this statute, the Bombay Prevention of Excommunication Act, is really an exercise in social welfare and reform. Justice Dasgupta answered it with a curious form of reasoning, if I may say so. The reasoning was that it was open to the Sayyidna to excommunicate on religious or grounds other than religion. And had they concentrated, that is the legislature concentrated only on other than religion ground, then perhaps you could say that it pertains to social welfare and reform. But if it is solely on religious grounds that you wish to interdict him, then no, because you are hitting at the kernel of the faith. And what is the kernel of the faith? That the head of the faith must be able to keep his flock within bounds. Otherwise, if the flock gets out of bounds, the entire faith collapses. So, that judgment seems to suggest, and of course the concurring judgment explicitly states, that you cannot, by using social welfare and reform a religion out of existence. So therefore, it is important to see that social welfare and reform doesn't attach to some essential part of the religion. The essential part to be determined by what the religion itself says is essential or inessential. Of course, the other part of the provision was the throwing open of Hindu temples to all Hindus. And Hindu here includes Jain, Sikh, Buddhist. The other interesting exception was where the word secular itself appeared in the original constitution. And it was that if the legislature felt that there were economic, financial, or political considerations which were secular in nature, that is, they are not religious per se, but associated with religion, then that again becomes an exception. Now, what do you mean by something associated with religion? You associate something with religion if, for example, you are paying a priest or you are receiving a donation. It is open to the state to say that the donation cannot be used for immoral purposes, for example, or that the priest is being paid something which is way above his station or way below his station. You can regulate. So, this exhausts the gamut of the individual right. You see how detailed and how specific and how brilliant it is. There are so many nuances which I think another constitution bench will have to go into, because the Dawoodi Bohra case itself is up for grabs now. 26, of course, deals with religious denominations. That's as opposed to the individual's right. And here, religious denominations, like minority institutions, are given the right to establish, administer, maintain, own property, and administer the institution in accordance with law. We then go to the next interesting aspect of secularism. And that aspect is the aspect which creates this wall between religion and the state. Article 27 tells us, and again it is a little peculiarly worded, because it says that you cannot, or nobody is bound to pay taxes if the tax is collected only for a religious purpose. Now, that obviously doesn't mean that you can collect a tax for religious purpose. So that article also requires deeper scrutiny. And 28, 1 and 3 speak of educational institutions which are run wholly or maintained wholly out of state funds. There again, you cannot teach any religion. So you have a clear bar between the teaching of religion in such places and otherwise. However, the bar is lifted when it comes to recognized institutions and aided institutions which are private. Because there, under 29(2), as I told you, every aided institution has the right to aid, irrespective of religion. So if the aided institution under its constitution not only is to teach its own faith, but is to conduct, let's say, a prayer in the morning, then you can't interdict it from doing so. So what does 28(3) do? It gives an individual a right to say that, look, I am not of your religious denomination. So when I attend, it will not be compulsory for me to either attend the prayer or to attend religious instruction. Two important exceptions are also contained, which also led Singhvi to say that there is no such wall in our country. And that is Article 28(2) and Article 16(5). Now, 28(2) specifically again speaks of a state administering an institution which is otherwise endowed by some religious trust. Now, there again, if religious instruction has to be taught, so be it, even though the state is administering. And the other is that you have a, let us say, a religious organization in which the charter of that organization says that only persons of that religious faith can be on the board of directors or can hold office under that particular religious organization. That again passes muster and cannot be touched. Now, having given you the four limbs of secularism as they emerge from our fundamental rights, there is one other interesting thing which occurs in our fundamental duties, which was again added by the 42nd Amendment. You have in Article 51, capital A, clauses E and F, which are very important. Because here the fundamental duty is of one citizen to the other. The state is not directly involved. And the fundamental duty under 51AE is that essentially harmony will prevail, and harmony will prevail by fraternity, that is common brotherhood, which transcends religious barriers. Very important. And then F says, don't ever forget that we are all the children of a composite culture. Very, very important. Not a monoculture. It's a composite culture because we have had a history, long history in this country of foreigners who have come and settled and then ruled us, and foreigners who have come and ruled us but not settled and gone away. So we have a composite culture as a result, which we must all respect. Now all this is very good. This is beautifully written, beautifully done in our constitution. How does it work on the ground? Not very well, unfortunately. If I may just take one case and all its ramifications, just take the Babri Masjid Ram Janam Bhoomi case. Now, incidentally, there isn't just one judgment, the famous judgment that everybody talks about. There are 4 Supreme Court judgments dealing with this. And the Supreme Court, unfortunately, does not speak in the same voice. It speaks in different voices. The entire thing begins with a clarion call first given by the VHP in 1984. This leads to the district judge in 1986 opening up locks where only pujaris were allowed to pray in the inner precincts, and a shilanyas being done in 1989, which is like a sort of foundation ceremony. This then gets followed and gains impetus by Sri L.K. Advani's great Rath Yatra, if you remember. That Yatra was supposed to be from the temple at Somnath all the way to Ayodhya. Seeing the vociferous tendencies that this would have, the Places of Worship Act was then enacted, to which I'll come a little later, in the next year. But despite that, unfortunately, on 6 December 1992, we all know what happened. And immediately after that, the government of India did 3 or 4 things. First, it appointed a Libaran Commission, which of course slept over it for 17 years and then delivered some report in 2009. Second thing that it did was, it had this Ayodhya Acquisition of Areas Act and concomitantly a precedential reference to the Supreme Court to determine, I would submit rather mischievously, as to whether there was a Hindu temple underneath the mosque. Now, both these came up for adjudication, but before they came for adjudication, in March 1994, a 9-judge bench unequivocally held through various judgments that secularism is part of the basic structure of the Constitution, and said that the dismissal of 3 BJP governments in Himachal Pradesh, Madhya Pradesh and Rajasthan by the President under Article 356 were valid because of the riots that broke post the breaking of the masjid. So we had one 9-judge bench judgment speak in ringing tones about secularism and the importance of secularism to our Constitution. Following up on that judgment, in October of the same year, you had a sharply divided court of 3-2 in Ismail Farooqi's case. Now, Justice Ahmadi happened to be part of the minority in that case and also happened to speak in the first judgment, which is the 9-judge bench judgment. And what he said was interesting. In the 9-judge bench judgment, he said that even if secularism was added in our preamble much later, it only stated an obvious position. It did nothing to change the position, which is quite right. Because as I told you, all the articles I have told you about tell us what secularism in our Constitution means. But in Ismail Farooqi, the majority, on a strained construction of this Acquisition Act, held that the central government, who acquired 67 acres, which was a much, much larger area than, let us say, the 2 acres of the mosque and its precincts, was really an exercise in a statutory receivership. Now, how did they come to this conclusion? You must hear. The Act contained a section 3 which said that the right, title and interest, that is everything in the 67 acres, will be taken over and will vest in the central government, first. Second, the usual thing of an Acquisition Act which follows, it is freed from every obligation, mortgage, debt, etc. Now, after all this is done, and after the vesting takes place, compensation at market value is to be given to these people, which shows that it's a vesting in law where ownership is actually taken away. Can be no doubt. However, Section 7, which spoke of management in the meanwhile by the central government, spoke of, in 7.2 in particular, a much smaller area that was occupied only by the mosque and its precincts, which let us say is about 2 acres out of 67. So what the court did was to split up the sections, even though they couldn't do so, in my humble submission, into a section 3 where vesting took place of everything, 65 acres, but did not take place so far as the 2 acres is concerned. And what took place so far as the 2 acres was concerned was only management, because at that point, the central government then would see that it would manage this particular disputed area, what they call the disputed area. Section 8 also had to be bifurcated, because Section 8 said you will pay compensation immediately. So they said no. So far as the disputed area is concerned, pay compensation ultimately when the entire dispute is over. So what they did was to actually bifurcate and legislate themselves and come to this very peculiar conclusion that there is a statutory receivership of the central government, which the central government can then vest in a trust. Now that's one other problem, because the vesting that takes place in the trust is exactly what is vested in you. So when you vest something in the trust, you're not just vesting the statutory receivership, you're vesting ownership. And ultimately you have to pay compensation to these owners. Anyway, another aspect of 7-2 also was that having broken down the mosque on 6th December, you say that the status quo as of the act will be maintained, which is 7 January 93, after the breaking. And that status quo meant that Hindu pujaris would pray inside. And that again was poo-poohed by the majority by saying, no, that doesn't mean anything, because the vast members of the public can't pray there. It's only a few pujaris. The minority, consisting of Justice Bharucha and Justice Ahmadi, took great exception to 7-2 and said that it is in the teeth of secularism to have this kind of provision, to give, in fact, a premium on something which was a dastardly and rascally act even as per the majority, the breaking of the mosque. And of course, they said that acquisition of an area for a religious purpose be directly in the teeth of secularism, so the whole act must go. Ultimately, of course, what went was only Section 4.3, which abated the suits in relation to the Ram Janam Bhoomi thing, because the suits then came back, and the presidential reference was left unanswered. The majority saying it's become superfluous, the minority saying that no, it was in fact one-sided. Because we are not told as to what would happen if you found that there was a Hindu temple, as a matter of fact, under the mosque. Suppose you found there was a Hindu temple, what followed in law? And suppose you found the opposite, equally, would the mosque be rebuilt? These were all questions left completely unanswered. So you had, on the one hand, Bomai's case, extolling secularism, and then you had this 3-2 split, where secularism came under a great cloud. Now to come to the other aspects. As soon as the mosque was in fact broken down, there were 2 FIRs lodged. One was 197 and one was 198. 197 concerned the lakhs of so-called car sevaks who came and actually chiseled the mosques down. And 198 was the senior leaders of the BJP party, LK Advani and company, exhorting these people to do so. Now, on the criminal side, therefore, you had these 2 FIRs, and until it came to me in 2016, quite by chance, in fact in 2017, when I was sitting with Justice Pinaki Chandra Ghosh, nothing had taken place with these 2 FIRs for 25 years. It's also astounding. Huh? So, what happened was, you had FIR 197, and you had, of course, to constitute a special court to try these offences. Now, you constitute that special court by consulting the High Court. You have to do it under Section 11 of the Criminal Procedure Code. So, you did so qua FIR 197. You omitted to do so qua FIR 198. So, the result was, what was to be a joint charge sheet, joint trial, got bifurcated. And ultimately in 2001, the High Court of Allahabad held, look, this is a rectifiable defect. Rectify it. Go back to the state government and tell them to consult the High Court. The CBI filed some half-hearted application. The state government said flat, no, we are not going to rectify it. The result was, Another charge sheet had to be filed in Raebareli against these 8, as opposed to the lakhs of car sevas. So now you had 2 trials going on simultaneously, one in Lucknow, one in Raebareli. And the criminal conspiracy, which was common to both, therefore, out of the window. Now, when all this ultimately came up to us, what we did was we put back everything using our powers under Article 142. I wrote the judgment. And what I said was that, look, you transfer the Raebareli proceeding to Lucknow, reinstate the 120B charge, the criminal conspiracy charge. You have one special judge trying this matter day to day. No adjournments will be taken by either side. Liberty to apply to us if there is any problem. And that the judge will not be transferred come what may. And all this must be completed within 2 years. Don't forget, these are FIRs of 1992, which are now being tried in the year of grace 2017. So anyway, 2 years were given. The special judge applied to us again after 2 years. And we said, all right, we'll give you a little more time. What is the progress you have made? So we saw. What was not known to us was that he was due to retire. So once again, 142 came to the rescue. And I think we made an unprecedented order, which is that he will not retire until he goes to judgment. So we caught him by the scruff of his neck and said, no, you will go to judgment. And it took him 3.5 years to go to judgment. And you know what he did? Acquitted everybody. And after acquitting everybody, what happened? He retired and he was made Up Lokayukta in the state of UP. This is the state of affairs in this country. Now, this is so far as the criminal side is concerned. Now we come to the civil side. The first interesting comment on the civil side is that you had the only per curiam judgment ever written. It's a very, very curious judgment because it was delivered by 5 learned judges of our court. Nobody knows who the author was because it was per curiam. The only other case in which there was a per curiam judgment was the Little Rock case in the US. Because if you remember, Brown versus Board of Education said, and that was again a very contentious issue in the US, as contentious as this, that whites and blacks as students will not have separate schools but will integrate. Now, they gave a certain period within which to do this. You will do it with all deliberate speed is what the original judgment held. Chief Justice Warren's judgment. That was done as the result of a compromise. Because had that not been put in, 4 southern judges would have stuck out and dissented. Ultimately, anyway, it came to Little Rock in Arkansas. And there was a governor called Governor Forbes. And Governor Forbes said, whoever it is, I will not take what the Supreme Court says the Constitution says it is because I equally can interpret the Constitution for myself. And if I interpret it for myself, I say nothing doing. I'm not going to do any such thing. And ultimately, because of this face-off, the district judge there said that, look, we will now desegregate, but we will do this after 2.5 years. Because just now, things are too hot. And then that came up in appeal to the Supreme Court. Finally, the Supreme Court then, in a per curiam opinion, said that no, whatever we say the Constitution says is what it says. You are bound to follow what we say. Don't forget, the US Constitution doesn't have an Article 144 like us, which says all authorities shall act in aid of the Supreme Court. So, in order to say this, they required to band together and to say it is one Supreme Court who is telling you this and you jolly well follow what the Supreme Court says. There also, Justice Frankfurter, of course, had to add his own bit. So, he undid the whole thing by saying Frankfurter J. concurring. Very similar to what happened here. Because here again, by way of an addendum, you had one other judge who is unknown, speak about his views. So anyway, obviously this case was so earth-shaking that the bench felt that the country desired or should have a per curiam opinion. Of course, finally, reams and reams of oral evidence, documentary evidence, etc., were gone through by the main judgment, which was a rambling 1,000-page judgment. I have gone through it very carefully. And ultimately, it divided itself into various periods. The mosque itself was built in 1528. You remember the first battle of Panipat was 1526, so 2 years after. And then the mosque continues as a mosque until there is trouble in 1853. This is the first time there's trouble. And after there's trouble, just as the crown is due to take over in 1858 from the East India Company, there is a huge fracas. And as a result of the fracas, a wall is built. Sorry if I'm going to go back. One more wall. A wall is built by the British between what is called the inner courtyard and the outer courtyard. Now, inner courtyard means the precincts of the mosque proper. Outer courtyard is what is just outside those precincts. So a wall was built. And after that British wall, prayer was conducted by both sides, on both sides. So the outer courtyard, prayer was conducted by the Hindus, inner courtyard by the Muslims. So it's a recorded fact that prayer was conducted by both sides right from 1857 up till 1949. Very, very important fact. Of course, in between, there were two other very interesting incidents that took place. 1885, there was a Mahant Raghubar Das, who was the Mahant of the Ram Janambhumi area in the outside portion. And he filed 2 suits. And he said, I want to construct a temple over only the outside portion, because not only is there a Sita Rasoi there, which was already there, but we have now built a Ram Chabutra as well. And I want to build a temple on this, being owner. Both suits were dismissed. And first appeal dismissed, second appeal also dismissed. What is important to note is that the claim was only qua the outer courtyard, not the inner courtyard. 1934, again you have a riot, in which the 3 domes of the mosque are badly damaged. Reparations are made under some British commissioner, and the mosque is repaired. And then finally in 1949, after independence, in December, there are 50 to 60 people who stormed the mosque and who put idols in there, as a result of which all Muslim prayer ceased. And an important finding is given by the court saying that this doesn't mean that they abandoned the mosque. At no stage did they abandon the mosque. So, it is important therefore to note that each one was praying on either side of the wall for this long period from 1857 at least up till 1949. Of course, an ASI report is gone into in great detail. The ASI in 2003 did a huge amount of digging in the area. And they found a number of artifacts belonging to 9 periods in history. Very interesting. Beginning with Ashoka and pre-Ashoka. So 250 BC and before. And then you got into the Sugha period, Pushyamitra. After the Sugha period, then you came to the famous Kushan period. And from the Kushan period, you went on to the golden age of the Guptas. Now, all this time, you have got only little artifacts. Post-Guptas, you come to the Rajput period, which is a period from the 6th century to the 9th century AD. Here you find something very interesting, because you find a circular shrine. And the circular shrine is said to be probably Shaivite. This is again very interesting, because ultimately in the judgment, nothing is spoken about it being Shaivite. There's a finding earlier. It is called a Hindu shrine later. And after another 3 or 4 centuries, in the Sultanate and post-Sultanate period between the 12th century and the time the mosque was built, you finally had this huge structure under the mosque. And the huge structure was probably a temple, said the court, and probably a Hindu temple. Now, this was despite the fact that Buddhist and Jain artifacts were also found. But one important finding that the court came out with was that there was no Ram temple under the structure. That's a finding of fact, extremely important. So with this finding of fact, they now proceeded to decide the suits. There were 4 of them, 1 on the Muslim side, 3 on the Hindu side, and 1 in the name of the deity, to decide the suits on possessory title, because you have to peg it somewhere in law. Now, the finding that the outer courtyard was used by the Hindus and therefore they had exclusive possession, no problem, all right. When we come to the inner courtyard, that's the mosque itself, there's a big problem. Because here, despite your finding that the Muslims were praying for this huge period from 1857 to 1949, you say, no, we can't say they were in exclusive possession, and this site was disputed. Now, it was disputed in the sense that there were egregious attempts to dislodge them, contrary to the rule of law, which is what the finding of the court is. And 3 times this happens. This doesn't happen once. So this happens in 1857, this happens in 1934, this happens again in 1942. And then you go on to say, therefore we can't say that this site is undisputed, whatever that means. And since this site is now undisputed, we can't say therefore that they have exclusive possession of this site. They, the Muslims. And therefore, since this is one composite whole, we now jump to the conclusion that the composite whole now belongs to the Hindus. This is the actual reasoning of the bench. And one other very, very important fact, that throughout this whole exercise, we are also told that every single time it's the Hindu side that has done something contrary to the rule of law. And for that, of course, reparations have to be made. What was the reparation? One would have thought, rebuild the mosque. No. The reparation was, we'll give them some land on which they have to build the mosque. So ultimately, we find that a great, at least in my humble opinion, great travesty of justice was that secularism was not given its due at all by these judgments. And as I told you, they've spoken in different voices. First 2 voices, then the second 2 voices, my voice and the voice of the 5-judge bench. But there is one very important silver lining in all this, and that is the Places of Worship Act. Now, this act was specifically brought, as I told you, in the year 1990, in order that we do not have the Greek god of Janus governing us. What do I mean? Janus is 2-headed, as you know. He's a Greek god. One face looks to the past, one face looks to the future. And because one face looks to the past will determine the future. The Places of Worship Act is the exact opposite. It is the Janus face looking behind is effaced. You will not look to the past. You will not try to counter historical wrongs by breaching the rule of law or by asking courts to do the same. And this very constitution bench spends 5 pages on it and says that it sounds in secularism, which is part of the basic structure, that you cannot look backwards, you have to look forwards. And what does the act say? Very important. Every religious place of worship is frozen to 15th August 1947. Now, anybody who tries to change this, and if there are suits pending at the stage of the Act, which is in 1991, those suits will stand dismissed. A bit. If any suit says that the character has been changed, the suit will be disposed of in conformity with this Act, which is the same thing, ultimately. And importantly, therefore, we have this frozen position as of 15th August 1947, so that short of Ayodhya, which was kept apart as a special case in those places of worship Act, all other places will at least be safe. And we find today, like Hydra heads popping up all over the country, there is suit after suit filed all over the place. Now, not only concerning mosques, but also dargahs. And according to me, the only way of countering this, because all this can lead to, is communal tension and disarmament, contrary to what is envisaged in both our constitution and in the Places of Worship Act. The only way to scotch all this and to cauterize all these hydra heads is by applying these 5 pages in this very judgment and having it read out before each district court and high court, because these 5 pages is a declaration of law by the Supreme Court which binds each of them. And once this is done, it is clear that the Places of Worship Act will take its due course. One other important thing, the minority judge in the High Court, Justice Sharma, had opined that this Places of Worship Act, as a matter of fact, does not operate pre-1991. So that if there's a conversion pre-1991, that won't be hit by the Act. The judgment goes on to say this view is completely wrong and in the teeth of Section 4.2 of that Act. So if this Act were to be applied as stated in this judgment itself, it will easily cauterize all these hydra heads, which are now popping up one after the other every day today. And I may only end by saying that in Justice Chinnappa Reddy's words, unless this is done, what he said will not come true. He said in the great Bijo Emmanuel case, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it.
Thank you, Justice Nariman. It was both an unalloyed pleasure and a privilege to have heard you speak, sir. We will now move on to the next segment of the evening. Juggernaut Books is proud to have published The Fearless Judge, a candid yet meticulously researched biography of Justice Ahmadi by his granddaughter, Insia Vahanvati, in which she gives us a glimpse into the career of a formidable judge and the mind of the man behind the robe. May I now invite onto the stage for the official release of the book, Justice Nariman, Senior Advocate and Rajya Sabha MP Dr. Abhishek Manu Singhvi, Senior Journalist Vikram Chandra, and our author Insia Vahanvati. Thank you all. Dr. Abhishek Manu Singhvi really needs no introduction. He is a distinguished advocate and politician, currently an MP in the Rajya Sabha representing Rajasthan. A senior leader of the Indian National Congress, he has served as the party's spokesperson and held prominent positions, including chairman of the Parliamentary Committee on Law and Justice. He is an eminent lawyer, the youngest person to have been designated senior advocate at the Supreme Court, and the youngest ever Additional Solicitor General of India. May I please now request Dr. Singhvi to address the gathering.
Justice Nariman, sitting and former judges of the Supreme Court, the High Court, the entire Ahmadi family, my colleagues and friends Tasneem and Huzaifa, the author Insia, Vikram Chandra, distinguished members of the legal fraternity, ladies and gentlemen. To be asked to speak after Rohinton is the greatest disservice Huzaifa could have done to me. You have to blame him, not me, if you get the feeling that you are tasting water after the heady wine you have just imbibed from the master of many parts. I certainly had the same heady feeling when he delivered the Dr. L.M. Singhvi oration on reincarnation. That's why I call him a man of many parts. Some years ago, as one of the series of memorial lectures in memory of my late father. And the wine gets better and better and better every time. I got to know Chief Justice Ahmadi, whom I usually refer to as Chief, more closely just around the time he became Chief Justice, although I knew him before that and had appeared before him many times in many cases as a judge. He was a close friend of my father who had left the country in 1991 before he became the Chief Justice of India. He had gone to as High Commissioner to England. But when Chief Justice Ahmadi picked me as the member, the junior-most member, in a tight-knit group of Indian lawyers and sitting Supreme Court judges to make a report to institutionalize ADR in India. At that time, I worked closely with him from 1994 to 1997. And in that capacity, I experienced firsthand his passion, his expertise for case management, for reforms in the administration of justice, for ADR. Over 3 years of Supreme Court summer recesses, our team, which also comprised sitting US Court of Appeal judges, sitting federal district judges, and a few US lawyers, and about 5 of us from the Supreme Court bench and 2 lawyers, studied the Californian legal system, the originator of the world's most successful ADR model, and attempts to introduce it in India. It was our report which ultimately led to the statutory encapsulation of a menu card of ADR options in Section 89 of the CPC. Some of these labors are documented in a published article in the peer-reviewed Journal of the New York University in 1997, where I had, as a young lawyer, the great privilege of being a co-author with the recently retired Chief Justice of India. Insia refers to some of this at page 194 of the book. But I refer to this intense interaction with Chief Justice Ahmadi when I was in my early 30s to underline some facets of that man. Firstly, he was always unfailingly courteous to the youngest member of the team. Secondly, he displayed his remarkable command over the nitty-gritty of civil and criminal procedure, a talent usually fortified by his tenure at the City Civil Court, where he started his career, one of the first to become the Chief Justice of India from that post. Thirdly, he was a patient listener who was prepared to make drastic changes if convinced, even if the suggestions for change came from the junior-most member. I remember that I told him to reconsider his idea of starting the American team's Indian tour from Allahabad High Court. And I reasoned that they would get a culture shock if they started with figures of lakhs of cases then prevalent in Allahabad, now of course much higher. Despite the insistence of the Allahabad hosts to continue with the original schedule, he changed it to Gujarat, Delhi and Calcutta High Courts. Fourthly, I always found him marrying the theoretical with the pragmatic. I also pointed out to him that statistically our research in California had shown that there was a fourth lesser known category of ADR which was quantitatively the most successful, and that used to be called in California the judicial settlement, where a sitting judge, who could by law never be the trial judge, acted as a mediator and settled cases. I strongly argued for that inclusion in our report. He gently told me that while he agreed in principle with the idea, he would rather drop it, and then reeled off figures of vacancies of each high court, and then concluded by saying that we do not have enough judges even to decide cases as sitting judges. Where is the question of finding judges, sitting judges to act as mediators? The sad footnote about this project, and I say it because we talked about it very often till just before his death, about 7-8 months before his death. The sad footnote about this project is that the actual report by our group appears to have vanished into thin air, vanished from the face of the earth. Whenever Justice Ahmadi and I met or telephonically talked, including my last interaction months before his demise, when I appeared as a counsel before him in what was to be his last arbitration, he would ask me if I could lay a hand on that report. I told him that it is not in the judge's library, nor traceable in the law ministry, and it was clear that some forces did not want attribution of this as an additional feather in his cap. Such are the mysterious ways of judicial politics. And Chief Justice Ahmadi, who always preferred to see the sunny disposition of mankind, was deeply saddened by the disappearance of this report. Ladies and gentlemen, this book is a treasure trove of Justice Ahmadi mega and Justice Ahmadi trivia. INSEAD does a wonderful job of fleshing out the man and not only Ahmadi the judge. His commitment to secular values was legendary, and I have felt it in my numerous conversations with him. Of course, I don't intend to remotely trespass on Rohinton's tour de force. Nobody should be foolish enough to try that. But I've always found Professor Bhargav's elaboration of secularism in Lincolnian terms very attractive. Professor Bhargav, formerly of Harvard, asks the question which he then proceeds to answer himself. He asked the question, he says, I can understand in Lincolnian terms why Lincoln said, by the people, because the people vote in a democracy. Then he said, I can understand why he said, for the people, because the elected must work to serve those who elected them. Bhargav then goes on to ask the third question. He said, why did Lincoln use this very odd phrase of the people? And then he proceeds to answer by saying, of the people is intended to convey a sense of co-ownership of democracy to each part of the polity. It is intended to attach to each person from the smallest to the biggest, from the smallest minority to the biggest majority, a sense of belonging to an ownership of the democracy as an intrinsic and inalienable component of that democracy. And whenever we fail to convey that sense of belonging or co-ownership, and whenever in particular we fail to cross-fertilize that with the other core word, very little used, fraternity, we fail to be a true constitutional republic. Justice Ahmadi's courage and conviction as a staunch secularist are narrated by INSEA in the context of his decision in the General Vaidya case. In the General Vaidya case, he held a late-night hearing and upheld the death sentence to the assassins of General Vaidya. In the wake of this judgment, concerns about his safety began to mount, particularly given the wave of high-profile assassinations at the hands of Sikh separatists at that time. The Chief of Security, fearful for Justice Ahmadi's life, repeatedly pressurized him to dismiss his Sikh secretary, citing the risks posed to his security and by his ruling. Bristling at the suggestion that an employee be dismissed based on his religious background, Ahmadi refused to relent. The Chief of Security had to content himself with upgrading the family's security to Z security, while the faithful Sikh secretary, remained firmly by Justice Ahmadi's side till he retired, and even after that. Chief Justice Ahmadi's lifelong fascination for Gandhi is also recounted by INSEA in the early part of that book, when she discusses Ahmadi the teenager. It was triggered again many years later, I discovered, when as a sitting Indian High Commissioner to Great Britain, my father in a chance conversation told him, Aziz Bhai, is it not strange that Gandhi finds no prominent place in the apex court? Chief Justice Ahmadi immediately realized the depth of the point made, and my father and he jointly supervised in record time the creation of an appropriate Gandhi statue and its installation where you now see it in the Supreme Court forecourt. When they inaugurated it, they both talked of how, above all, Gandhi's virtue of fearlessness must imbue the Supreme Court. Chief Justice Ahmadi was a multifaceted personality, and many of those diverse traits are beautifully brought out by INSEA in this labor of love. An optimist who never compromised on fundamentals, a warm and enveloping personality who spawned lasting and lifelong friendships, a person who held his ground in judgments like Bommai and Session. Chief Justice Ahmadi went by legal principles and not by the expediency of playing to the galleries. Here was a man who could handle the hot potato of reservations in Indira Sahni with the same aplomb as he dealt with the famous Chandra Kumar tribunal's case. The latter, of course, what most impelled him was his case management concern about not flooding the Supreme Court directly with service matters. In later years, after retirement, he opened up to me several times about the tough moments he faced on the bench. And he used to say that some of those toughest were at the apex court. Despite being buffeted by not too pleasant judicial winds during his chief justiceship, and you can see that I can be a diplomat in using words of studied moderation, he maintained equanimity and composure right through, but more importantly, managed to initiate many constructive changes in the functioning of the court without, I think, 100% cooperation or cohesion. It was during this time that computers were first put to effective use and case batching started in good earnest. It was no mean achievement that he left the Supreme Court arrears around 18 to 20,000 after having inherited a court of 1,20,000 pending cases. No wonder, as Chief Justice Chandrachud, recently retired, has also said, and I heard this from Lord Woolf personally, the distinguished Lord Chief Justice of UK, who visited under the Indo-British colloquium started by my father at that time. He referred to Justice Ahmadi as a case cracker. Justice Ahmadi used to love my wisecracks about judicial politics, possibly believing himself to be one of its victims. I told him that 2 decades before I was a student at Cambridge in the 1980s, a chap called J.A.G. Griffiths had written a small paperback and caused a furor in UK by merely titling it the politics of the judiciary. This is way back in 67. I told Chief Justice Ahmadi that Griffiths would blush if he saw the Indian variant of Indian politics. I remember him laughing and nodding vigorously in agreement. Friends, there is no better ode to Chief Ahmadi and his wife than put by INSEA right at the beginning of the book. And I quote her, "You fought the good fight, you finished the race, may you always fly free, may you rest in eternal peace." Thank you very much. Sorry. It's a little unsafe here.
Thank you, Dr. Singhvi, for that moving tribute. In the next part of the evening, our author Insia Vahanvati will be in conversation with Vikram Chandra. An award-winning journalist, Mr. Chandra is the founder of Editor G Technologies, a startup that seeks to transform video news through innovation and user experience using artificial intelligence. Earlier, Mr. Chandra was a TV news anchor for NDTV and presented much-loved shows such as The Big Fight and Gadget Guru. Insia Vahanvati is an independent journalist, commentator, and scholar with an interest in the subjects of minority rights, media studies, hate politics, gender and caste-based violence, particularly institutionalized human rights violations in racial and religious contexts. Her analyses and commentaries on right-wing politics and on the geopolitical implications of domestic political ideologies and policies are published in Indian newspapers and publications abroad, as well as by international think tanks and geopolitical advisory firms. I would now like to invite Mr. Chandra alongside Ms. Vahanvati onto the stage for a conversation about the book.
Thank you so much for having me here, and it's such a pleasure to be talking to you. I was a young cub reporter in the early 1990s, and for a reporter, 92, 93, 94, Justice Ahmadi was for us the majesty of the law. He was somebody who we would look up to, he would revere, admired him in so many ways, and that's why it's such a pleasure and such a privilege, quite honestly, to be here, talking to you, about Justice Ahmadi and his legacy. But let me just start with the obvious question. Why did you decide to write this book, and why now? Why at this time?
So the idea for the book originally came from a thought that my grandfather had while he was alive, which was to write an autobiography. And he used to tell us this. He used to say that, one day I'll write a book, I'll write my life story. And he'd started making a few notes, which I knew that he was making with the intention of one day including them in his book. But unfortunately, as we know, he was unable to do this. He didn't get the time. So when he passed away last year, I started receiving a little interest from publishers who wanted to know if there was going to be a book about Justice Ahmadi and if I was planning on writing anything. So that's when I decided to take a look at his notes. And the more I read, the more I was reminded of the qualities that made my grandfather. So the very sharp, incisive way that he had of looking at the world, the very practical yet commonsensical approach that he applied to even the most complicated of problems, the qualities that made him the judge that he was, but also the principles and values that he'd lived his life by. And I just felt that his story was too important to go untold. And his legacy is a national treasure. It belongs to the nation and it deserves to be protected. To the second part of your question, why now? A lot of the values and ideals that my grandfather dedicated his life to preserving, I feel are becoming diluted in present-day India. And that's something that I feel very sad about. And I think it's important to remind people that the idea of India that Justice Ahmadi had and intellectual giants like him had for us is not necessarily the India that we live in today. But it's also important to remember that India wasn't always like this, and it doesn't always have to be like this. No, it's not.
We'll shift this.
Do you want to switch these off?
You were talking about the idea of India.
Right. And it's important to...
But this one is, so I'll just hand this to you.
Thank you. And
It's not the big fight, so I don't have to shout over you or grab the mic away.
so I did feel that it was important to remind people that India wasn't always like this, and it doesn't always have to be like this. There are other ways to think of our future when we imagine the future of India. So these were some of the thoughts and events that eventually led to the book.
Let's just start with the story of his life, because reading the book, that part is really, really interesting. He had such a unconventional childhood. His entire path to the chair of the Chief Justice was an unconventional path, district court, going all the way up there. Talk to us a little bit. Obviously, people should read the book to get the entire story, but give us a glimpse of that, and also the extent to which that then shaped a lot of his priorities, in particular looking after the poor and the disadvantaged.
So Justice Ahmadi had a very interesting childhood. His father was a sub-judge in pre-independence India, which essentially meant that he was often posted to smaller towns and villages. So Justice Ahmadi spent a large part of his childhood in rural India. And this is significant because it allowed him to see the true character of India. So one of the social issues that he was very vocal about throughout his life was the problem of caste. Caste-based violence, caste-based discriminations. And this is because of these early years in rural India that he had seen the ugliest face of caste. So he had seen things like people being beaten up for drawing water out of wells that were not meant for them, or being forced to tie broomsticks behind their backs when they walked so that the broomstick would sweep their footprints away, or being forced to bang two thalis together as they walked past a village so that upper caste people would know that a lower caste person is passing by, because they felt that the shadow of the lower caste person might contaminate them. And also we have to remember that he was only 15 years old when India gained independence. So he had seen partition as well. And he had seen the communal anxieties that partition brought with it. In fact, several of his friends had to almost flee to Pakistan almost overnight at the time because of the way that things had become. And as a rebellious teenager, he spent a lot of time outside the home, interacting with people from all walks of life. So not just educated people or people who came from means, but from a variety of different backgrounds. And this, I think, is very important because it allowed him an insight into the realities of life for common people and for vulnerable communities. And it also forced him to start thinking about larger questions like equality, justice, fairness, what these things mean in a common man's life and what they mean for vulnerable communities. Because you see, often what happens is that you may see a judge who has a very strong foundation in the law, but if they are not well versed with what we call the ground realities of people's lives, then you can see that in their judgments. In Justice Ahmadi's case, the opposite was true. Because he was very well versed in these ground realities, his judgments were very practical and very easy to implement. And this is something that you would notice even in the language that he used. Rarely, if ever, would you find him having used very flowery language or very long sentences that are difficult to follow. He made a deliberate attempt to use very simple, very easily understandable English. Because you see, his time in the lower judiciary and as Law Secretary of Gujarat had shown him that eventually the person reading the judgment and implementing it is a government functionary. So the easier the language, the easier for them to understand. And the more simple and direct the instructions, the easier it is for them to implement. I'll give you an example which I've mentioned in the book as well. So one of the seminal cases of Justice Ahmadi's time as a High Court judge in Gujarat was a case that had to do with exploitative working conditions of sugarcane workers. Now, these were migrant workers who would come in from Maharashtra and work in the sugarcane fields of Gujarat during the harvest season and then go back home. And for this, they were paid some 5 to 7 rupees per day. Now, this case came to Justice Ahmadi in the form of a letter. It was an anonymous letter, which he then directed to be treated as a PIL. Here, the bench directed that the minimum wage of 5 to 7 rupees be increased to 29 rupees, which is a huge increase. And the bench knew that the sugar industries are going to be very upset with this order. They also knew that the sugar lobby was very strong, so they would try their very best to avoid making these payments. So the practical implementation was also included. There was a timeline provided within which the payments had to be made. The place of payment was also specified. It couldn't be made in the fields because record keeping in the fields can be quite poor. So it had to be made at factory gates where proper counting could take place. And the bench also constituted a small team of lawyers to go and oversee this operation to make sure that it was done correctly and honestly. And you see, this is the theme that you find throughout Justice Ahmadi's judicial career. Whether it was in landmark cases like Indira Sahni, where he emphasized affirmative action as a component of equality, or in the very many cases where he defended the civil liberties of ordinary citizens when faced with excesses of state. Because it's not just the delivery of the judgment, it's the administration of justice that he was more focused on.
Well, you know, when you're talking about his legacy, and we talk a lot right now about judicial reforms, institutional reforms. There's so much talk, for example, about the pendency of cases that we see right now. So that would be, he actually walked the talk on that. I mean, pendency of cases. We were just hearing, Abhishek Singhvi talking about how he got it down to 28,000, which was, I mean, if only we could do that right now, it would be quite a miracle. How do you think he worked at that? And do you think that's one of the most important parts of his legacy, those reforms?
The reduction of case pendency?
And other
yes,
reforms.
I do believe that that is one of the most important elements of Justice Ahmadi's legacy when it comes to institutional reforms. You see, when he became Chief Justice of India, he inherited a caseload of 120,000 cases, as Dr. Singhvi has just shared with us. And by the time he demitted office, 2 years and some months later, this number was down to 18,000. And this is something that has never been replicated on this scale ever again. And the way that he managed to do this was by setting into place systems and processes. So, for example, proper classification of cases, categorization of cases, efficient docket management, things like maintaining the composition of a bench until all the cases in a particular category were not heard and disposed of, so that the bench wouldn't lose momentum. Creation of different tracks, like a fast track, normal track, medium track, so that different cases could proceed at different paces. And he also embraced technology. So for the very first time, computers started being used in a very extensive way in the Supreme Court. Judgments were digitized to make sure that they were accessible not just to the bar and the bench, but also other people like journalists and academics. And these methods, when put together, they worked wonderfully. I mean, the numbers speak for themselves. And of course, it earned him the name of case cracker.
Yes. Well, you know, you've titled the book, The Fearless Judge. You were his granddaughter. So you must have been up close seeing the pressures that can sometimes be brought to bear, even on a judge of the Supreme Court, even perhaps a Chief Justice of India. The pressures and also the temptations, and we sometimes hear that spoken about even now when it comes to the delivery of justice in the country. What did you make of that, and what did you observe as his granddaughter?
You know, I think as far as Justice Ahmadi was concerned, he kept it very simple. The judiciary is an independent institution with a primary duty towards its citizens, towards the protection of their rights, civil liberties, freedoms, etc. So, if you look at it through that lens, then decisions become easy. And I think that in Justice Ahmadi's case, it was also a conscious decision to define his own legacy, to determine how he wanted history to remember him. You know, a life of a judge is a pretty tough life. People who are not from the legal field, they think it's a life of a lot of power and big bungalows and red beacon cars and all of that. But in truth, it is also a lifetime of hard work and sacrifice. And it does take a different level of strength of character to be able to do this job. And every now and then, a judge will be faced with a difficult decision. Often it comes in the form of a choice between personal ambition and the right thing to do, what is good for the country. And that's when you see the true mettle of the judge. For Justice Ahmadi, this came to him in the form of the Ayodhya case. A case in which he dissented knowing fully well the possible repercussions of going against the executive and the Chief Justice of the time. But he did it anyway.
No, you talk about that, I think page 156 to 158 of your book is detailed a lot in that. We were just hearing Justice Nariman talking about his dissent in that particular case. And it sounds as if a lot of pressure was brought to bear. And he's including the possibility he wouldn't become the Chief Justice. But he went away and delivered that dissenting note irrespective.
That's right.
Tell us a little bit about that, because you were presumably hearing some of the conversations and those uneaten meals that he left to go away and take calls.
So I actually remember this time very well, because I was about 10 years old when the Babri Mosque fell. And I remember it being a time of great tension in our home. And I remember my grandfather being extremely distressed in those days. You see, if you've read the Ismail Farooqi judgment, you will notice that there is a huge emphasis laid on the loss of secularism. And there's a certain anguish that you can sense from the way the judgment has been written and the elements of it that it highlights. This is because both the dissenting judges, Justice Bharucha as well as Justice Ahmadi, were very deeply pained by the idea that the Supreme Court should be seen to be favoring one religious community and disfavoring another. They felt that the majority judgment was almost in some ways like a tacit acceptance of the demolition, because there was no mention of any consequences for the people who had engaged in the demolition. And also there were no orders that prevented both communities from offering prayers at the site. In fact, the effect of the Ayodhya Act was such that it would require the idols to remain in the masjid where they had been placed and for pujas to continue as they had been doing, but at the same time, barring Muslims from offering namaz at the site. So after retirement, my grandfather spoke quite publicly and quite freely about his misgivings in this case. He also criticized the Supreme Court for granting the permission that eventually permission for the car seva that eventually led to the demolition. In fact, he has on more than one occasion gone on record to say that had this permission not been granted, the Babri Masjid would have been standing today. And he also maintained that when we speak about ownership, we have to remember that India is a very old civilization. It's thousands and thousands of years of civilization upon which our current civilization stands. So how far back shall we go to claim ownership? And how can this even be proved in a conclusive way? And you know, not many people know this, but had it been left to Justice Ahmadi, it's quite possible that the Babri issue would not have entered courtroom litigation after the demolition. You see, being the secularist that he was, all that he wanted to see was for all the communities of India to get along and to live in peace and harmony. So he was very upset with the growing animosity between Hindus and Muslims that he was witnessing at the time. And therefore, he had made a very strong case to the Chief Justice of the time, asking him to explore the route of mediation. And this is back in the early 90s, where mediation was quite rare and uncommon. But he was desperate to find a way to diffuse the situation rather than escalate it. And he felt that courtroom litigation might prove to be too adversarial a process for an issue that is so sensitive and so emotionally charged. The idea being to avoid decades and decades of courtroom battles that would only increase the acrimony between the two communities. But sadly, that is exactly what has happened.
Right. I know we're running out of time, but I'm going to try and sneak in one last question. We know Justice Ahmadi, the Chief Justice, and you can read all about it in the book, but talk to us a little bit about your grandfather, the person. And perhaps that story cannot be completely told without you also talking about your grandmother.
Yeah, that's right. All right, so in our family, my grandfather was the undisputed head of the family. So there was no decision that could go through in his children's lives or his grandchildren's lives without his approval. But like you said, his story is not complete without my grandmother. And she was, I think, his greatest source of strength. And I have to say that it was at least in part her silent yet rock solid support that gave him impetus, that spurred him on to do bigger, better things, to achieve more, to do more. As a father and a grandfather, he was always up for conversations with us, always up for the exchange of ideas. In fact, I have learned so much in my life just from engaging with my grandfather on a regular day. And he had this very reassuring presence about him. He wasn't very expressive, not very overtly, but he had this very solid, it was almost like he was this big banyan tree, and you felt like, as long as the tree is around, everything in the world will be all right. So he had that quality, he could make you feel that way. And he was very mischievous. He had this very dry, very witty sense of humor, and these very clever lines that would come at you when you weren't expecting them. In fact, if we haven't run out of time yet, I'll share an anecdote.
Well, I'm sure we can quickly sneak in an anecdote on popular demand.
All right, so this is when Justice Ahmadi was Chief Justice of India, and he was getting a haircut. So he was sitting in his hairdresser's chair, and the hairdresser, trying to be extra helpful, he says, Chief Saab, your sideburns are becoming grey. Should I dye them black for you? So my grandfather turned around to the poor chap and said, my dear man, it has taken me 60 years to make this white hair black. Do you want to ruin that in 1 minute? So that was Justice Ahmadi for you.
Well, that's absolutely fantastic. There are plenty of other anecdotes, but I'm going to urge people to read the book to really get the full sense of it. Thank you so much. And
thank you very much.
It was a real pleasure reading that book.
Thank you very much.
Thank you, Insia and Vikram, for that wonderful conversation about the book. I would now like to introduce Mr. Huzaifa Ahmadi, son of Justice Ahmadi. Mr. Ahmadi is a senior advocate and has been practicing before the Delhi High Court and Supreme Court since 1991. With extensive experience in litigation and arbitration, he has represented clients across diverse legal domains, including constitutional law, civil and criminal matters, tax disputes, and administrative law. Mr. Ahmadi will now deliver the vote of thanks.
I know I stand between all of you all and dinner, so you will forgive me for saying a few words, but I hope I'll be able to whet your appetites. Everyone's spoken with great affection about Dad. I'll just add a few words about him and something which, defined him and defined his persona, defined his character. And one thing that stood out is that even in adversity, and the highest adversity when he was in pain during his last days as well, he never lost his sense of humor. So his Hindi or Hindustani or his Urdu was pretty fractured. He normally spoke Hindi, the Bombaya Hindi as we call it. And while in the hospital once, when the nurse trotted in at about in the afternoon and said in Hindi that, "Sir, aapka zara blood sample lena hai." He looked at her very plainly and with a very dry sense of humor that he always had. He just said, "Hai hi nahi, kuch bacha hi nahi hai." He says, "Subha aake le jata hai, दोपहर में आके ले जाता है, तो बचेगा क्या, कुछ है ही नहीं." Similarly, once when he was after the doctors, requesting them to discharge him as soon as possible from the hospital, and when one of the doctor would come to him every 2 days, and he would tell him that, "Look, where are you going to discharge me and send me home?" So the doctor once said that, "Sir, 2 more days." So he says that, "You take me back to my days as a judge, and you remind me of an unprepared lawyer who's always asking for adjournments." Dad was secular to the bone, and secularism for him was a way of life. But he never hesitated in standing up for what he thought was right, and that included a very firm commitment to his own community, that is the Muslim community. He was never worried about being labeled as being pro-Muslim or communal if he felt that that was the right thing to do. And one incident in the Gujarat High Court, where he sat once on a committee to just select class 3 staff. And in the list that he had prepared, there just happened to be 2 Muslims, 2 Hindus, and 1 Christian. And one of his colleagues remarked to him, saying that, "You appear to be packing the staff with Muslims." And this is what he was told. To which he sharply retorted, he said, "My list happens to have all religions. I am sure, and I can put a wager on it, that the list that you have prepared will have no Muslim, despite the fact that there are a large number of Muslim applicants before you. So therefore, please ask yourself the question, who is communal, you or I?" Therefore, comments such as, when he was in office and he was accused of Muslimizing the court by some of his colleagues didn't really bother him at all. He continued to do what was right and continued to appoint people whom he felt deserved to be appointed. He also showed remarkable grit often in taking decisions, notwithstanding the fact that he was fully aware that some decisions or sometimes doing the right thing may make you unpopular in the short term. I would therefore commend my niece for giving an apt title to his book. He was truly a fearless judge. A few words about my dear mother. Dad wouldn't have been what he is but for my mother. She stood by him through thick and thin, like the Rock of Gibraltar. And I quote from one of Dad's own pieces, where he says, and I quote, "My wife Amina has always been a wild person, but she is a strong lady. She has always been an ideal homemaker who has brought up our children marvelously. She indeed contributed a lot in my life. She is an unsung hero who always believes in work and not credit. To me, she is a great life partner, friend, and guide who also has a great sense of understanding and respect. She has indeed made my life easy and happy. I am highly grateful to Allah for giving me such a nice life partner. Both Justice Nariman and Dr. Singhvi were relatively young at the bar when they appeared before Dad. And I vividly remember him speaking about both of them with a great deal of affection and saying that they would shine in the profession. Well, shine in the profession for both of them is today an understatement. Thank you very much, Justice Nariman, for a brilliant speech on secularism. Which for Daddy was a way of life. Thank you, Abhishek, for a brilliant opening remarks on the fearless judge. Both of you would have made Mom and Dad indeed very proud. Thank you, Vikram, Chandra, for being here and having this wonderful book discussion. Many thanks to all the judges of the Supreme Court, the High Court, sitting and retired, senior advocates, my friends, family, and this wonderful audience for taking time off their busy schedule on a working day and being here for this lecture in my father's memory. On behalf of the Ahmadi Foundation, I can say you all made our day. Thank you. Before I end, a word about my niece and the biography, which stands out because it doesn't just tell a single story or is not about subjects in isolation, but are a reflection also of the times, of society, of politics, of culture, and the law in which Dad lived and also shaped. My niece is accustomed ordinarily to my criticism, but on this occasion, I will make an exception. She's done brilliantly. I think she does deserve a big hand. Do give her a big hand. Thank you very much for being here. Good. Thank you.